Welcome to episode 74 of the Cashflow Connections podcast. The topic for today is our Series LLCs, the asset protection strategy of the future. Today, we're going to talk about an interesting topic, which in my opinion is right on the cusp of what is going on in the world of asset protection, especially as it relates to real estate investors. If our guest today is correct, and if what he is saying ends up being solidified in the court system, it could be extremely good news for people that have a lot of active investments and a lot of entities. For example, I think I have 13 entities right now, and my organizational chart for my business is getting pretty insane, and it's only going to continue to be more complicated. But if this strategy ends up being something I can implement, I could potentially roll almost all of that into one LLC and then file only one tax return. Well, let me restate that. If I was in any other state besides California, maybe, because California, unsurprisingly, is the only state to explicitly weigh in on the matter and to say, no good, each series has to file its own return. But let's say I wasn't in California. For anyone outside of the state, that is exactly what this could mean. I'm going to go ahead and let our guest describe to you what a Series LLC is and discuss the current state of case law regarding the Series LLCs. But I do want to put two caveats out there. Number one, this show is not meant to provide legal advice, so you should always do your own research, and you should definitely hire an attorney when it comes to anything relating to asset protection. And number two, one of the reasons why this conversation is actually interesting is because the concept of Series LLCs, particularly as it relates to asset protection, is not 100% ironed out in the case law. So implement this at your own risk. I'm not personally doing this right now, but it's certainly something that I'm interested in, especially in terms of having a conversation about it. Now, on the other side of that discussion, though, is that when LLCs themselves were first invented in Wyoming in 1977, the conversation sounded very similar. There are a lot of attorneys saying, oh, those people out in Wyoming are crazy. They don't know what they're doing. The LLC isn't a viable vehicle for asset protection. It's too flexible. It's too cheap. It's too new. And then pretty much every state ended up creating their own LLC and LLC legislation. And now it's common practice because of how advantageous it is. That very well might be exactly what happens regarding this conversation and Series LLCs. So in this discussion, we're going to talk about what are some of the benefits of implementing this structure and strategy and how it could impact your business. We'll discuss some of the things you should be cautious about when creating your Series LLC structure. We're also going to talk about how you can hold assets in land trusts and therefore be completely anonymous. As our guest says, if they don't know you have it, guess what? You're probably not getting sued for it. And so land trusts are a great vehicle to keep that anonymous. And we're going to talk about Delaware statutory trusts and how they allow people to 1031 into syndications, which is something that is becoming more and more common these days, as we've seen some pretty amazing gains in a lot of real estate asset classes all around the country. Hey, also, thank you for everyone that ended up signing up for the CFC mentorship program. I really didn't know what to expect, but we sold it out for this quarter very, very quickly. So we're actually going to let these students go ahead and start in January. It's about a 3-month program. We also ended up having a waiting list. So because of that, it's very likely that we will reopen the program again sometime in 2019. So I'll make sure to keep you guys posted on that when I do decide to reopen the program. And if you want to get on the waiting list, you can just go to cfcmentorshipprogram.com and click apply now. And so we'll have your information and we'll reach out next time we reopen the program. All right. I hope you enjoy the episode. How's it going, everyone? Our guest for today is Scott Smith, who is the founder of Royal Legal Solutions, where he offers tax, business, and legal strategies to real estate investors. Scott spent the last 8 years of his career diving through case law, reading the ever-changing tax code, and analyzing real estate investments so you don't have to. He specializes in asset protection, and part of the goal of his business is to make his clients truly judgment-proof from creditors. He uses a combination of legal expertise, experience as an investor, and love for helping others protect and grow their business to build ironclad asset protection plans for his clients. And today, we're going to talk about asset protection in general, but we're specifically going to focus on the Series LLCs, which are really fascinating. I know that Scott has an interesting perspective on. So Scott, thanks again for coming on.
Oh, it's really great to be here. I really love talking about this topic. It's one of my favorite things. I've been, longtime real estate investor myself. And one thing I realized is that, we're all working on real estate investments to be able to create this passive income and to be able to create this lifestyle that allows us to leave our jobs or to retire, or, to be able to, really seize life in the way that we're wanting to. And one of the great things about asset protection is that it's really what gives you that extra security blanket to know that you're safe, because we really can't enjoy our lives to the extent that we really want to until we can know that we're not under a threat of something that can really go wrong. And that's the kind of security that we've been able to help with over 2,000 clients across the United States, protecting over $1.3 billion in assets. So I'm stoked to be able to share with you guys what are the best and the brightest strategies that people are using right now.
Yeah, and that's a great point. I think that we've all kind of been there. You start to experience a little bit of success in real estate business or otherwise, and you realize, oh, wait, now I've got something to lose. I need to invest some time and energy and some resources into ensuring that I keep this, whether that's through insurance or more complicated asset protection strategies. And I think that everyone is on a certain point of that scale. And so this conversation will definitely open a lot of people's eyes into what some of those strategies are that maybe they haven't been considering themselves. So yeah, again, I completely agree there. So before we jump into some of the details, let's talk about asset protection from a big picture perspective. What are some of the leading causes of the problems that people face when it comes to protecting their own assets?
Well, a couple of the major things that happen is a lot of people think that their insurance alone is enough to protect them. And they get a lot of bad advice that people that really don't understand the role of insurance in this much larger tapestry of what it means to protect yourself. So a lot of people are like, okay, well, I have insurance, it's going to protect me, and so I'm probably fine. I don't need asset protection. But what they don't realize that, fundamentally insurance companies are in a game of collecting premiums and denying coverage whenever it doesn't suit them. And that insurance only protects you from accidents, which is, the majority of claims are those accidents called negligence, right? But there's a number of other things that can happen where, a car accident can exceed the limits of liability of your insurance policy, or that the claim against you is for a breach of contract or an allegation of fraud, which can occur just from a simple email conversation. And none of those things are covered by insurance. I've seen an investor lose over $3 million from a single lawsuit because he had all his real estate in his personal name, and he thought insurance was enough to protect him. So the first thing is realizing that insurance is great. Huge proponent of it. We should all be very well insured, but it's not sufficient.
Yeah, definitely. And you do see that take place. I mean, you get both of the spectrums there. You get people that are not receiving the claims that they're making because of maybe some paperwork that wasn't completed correctly, or maybe that they were found to be guilty of something, some ghost negligence, for example. Or you get a major accident that takes place on a property and you're not appropriately dividing those properties separately, or you've linked them to your personal name, and you can see the overrun where you may have $1 million plan. Well, there's a $5 million lawsuit against you. You can get completely wiped out in a variety of ways. So yeah, that's a good starting point. And then when it actually comes to putting the insurance portion aside for a moment, when it comes to some of the challenges we see, even with people that do have a non-insurance based asset protection strategy in place. When it comes to that, what are some of the leading challenges there? Do you see most of the problems coming from things like marriages breaking up, or do you see incidents on properties? What are like the top 3 or so most important things that you want people to be careful of when it comes to asset protection?
Well, asset protection is always about being preemptive. The law will always protect you if you're proactive in whatever you're putting in place, right? It's tough to talk about in a really general sense of saying, here's all the things that you can foresee going wrong, because life is actually much too random, right, to really anticipate every possible caveat of what can go wrong. But what you can do is put some foundations in place that puts you in a position that says, no matter what happens, I'm going to be okay. So when you're thinking about marriage and divorces and protecting assets in that realm, you want to start attacking those types of issues proactively by talking to, a family law attorney, and also, somebody like myself to say, okay, what am I actually going to do here? Because this thing looks like it's going sideways on me, and I need to know what kind of position I need to put myself in to be, fully protected, right? That's a proactive measure. Outside of divorce, though, what we all need to be thinking about is lawsuit protection in terms of how do we do 2 things. The first thing that we need to do is take all of our assets and hold it inside of an anonymous asset holding company that has strong charging order protections. So number 1 is the asset holding company, and number 2 is an operating company that doesn't own anything but does all of your active businesses. So if you're active in the business world and you're constantly interfacing with people in the outside world, signing contracts, doing other types of deals and communications with hiring contractors, otherwise engaging in business in the outside world, you need to be doing that through an operating company to protect you personally. The idea here is very simple, is that you want to be in the same position that the uber rich are in. The uber rich don't own things. They have companies that own things. That's your asset holding company. We make it anonymous so people can't find out that you even own the company or what your company owns. And then alternatively, the really rich don't actually do anything. They have companies that do things for them. And the reason why is because when you're out there and actively engaging in business, that's the opportunity that people would have to sue you. And so we want them to have to be blocked by a company that says they try to sue, but the recourse they have is against the company. It's not against you personally, which protects your credit and protects you from being involved personally inside of a lawsuit, which can have these huge emotional and psychological tolls associated with them. So that'd be the number one and number two is you need an asset holding company and you need an operating company. The types of asset holding companies that you might need can really depend upon the types of assets that you have. So what are the types of assets that you think that the audience members would typically have and the types of investors they would have here? And we can identify those and talk about what types of strategies would be most appropriate for each of those different types of people.
Yeah, sure. So I guess the way that I think about it and kind of guide me through this as well is that there's basically two kinds of real estate investments that you can make. There's active investments in which you are the main operator of the company. Let's say, for example, you buy a single family house and you are interfacing with the management company. You're making all the day-to-day decisions. You have the skills and the power to buy the property, sell the property, increase rents, etc. If something goes wrong, you hire the manager to fix the problem in like a toilet, for example. And then on the other side of things, which I view as being categorically different, is investing in an LP of some kind where you're a limited partner in an LLC or typically the either A shares or B shares, and you don't have a lot of voting rights. You don't have a lot of control. You don't have any really serious day-to-day management or oversight and transparency. And because of that, there's a categorical difference in there, not only in terms of the control, but also in terms of the liability associated with that type of investment, that type of way of owning real estate. Is that kind of a fair delineation? Do you think that those two cover it, or are the others that maybe I'm not kind of considering?
Yeah, I think those are two of our great place for us to start. So let's just start with the first one, which is what do you do if you have assets that you own the single family homes directly and that you're looking to protect yourself from your, let's say, like 3+ single family homes or multifamily apartment complexes. You actually own the physical asset. For that type of investor, the best strategy you can use is a Series LLC structure in combination with anonymity trust. What the Series LLC does is you can form it in one state like Texas, Delaware, or Nevada, and you can use it anywhere. A Series LLC is just like a normal LLC. What they do is that they just create a new section of the code that says, and we're going to allow the normal LLC to have this special caveat to be able to create individual child series. So just like any other LLC, you can form it in one state and use it in another. It's been around for over 20 years. Nobody's actually challenged it ever to say that it's an invalid structure or that it's weak in any way. The laws on it are actually very clear, which is why nobody's challenged it. But what's cool about the series is that you can form one company, have one EIN number, one tax return, one set of books that you have to manage. But the Series LLC allows you to create an infinite number of what we call child series, each one of which acts as if it's its own LLC. But it doesn't have any filing. It's just merely created on your own desktop. But it has all of the protection in place. So you can create one company, have one company to manage and maintain. But that one company then can create its own individual, baby LLC, so to speak, and create as many as you want, and they're totally free. And so you can compartmentalize then every single asset for free. So if something happens with property A, they can't go after property B, C, D, et cetera.
Okay.
Now that in itself is the best type of protection you can have from liability.
Yeah. So just to clarify for people that aren't, privy to this structure, it's basically there is a parent LLC, and then within that parent LLC, there are series or individual, I don't know how to say them other than saying a series, but it's basically they're compartmentalized into specific entities or assets that are property specific. So let's say you had the Scott Smith LLC, and then within that Scott Smith LLC, you had 5 properties. You had the Scott Smith Property 1, series, the Scott Smith Property 2 series, the Scott Smith 3, 4, and 5 series. And the idea is that the liability is limited to those one particular series, which are on a per property basis. Is that a fair summary of what you just outlined?
That's exactly correct.
Okay.
And that's exactly the way series structures work, and that's exactly how the laws are written for the series to provide them that type of protection. And what you do if you want anonymity in place, which is extremely important. Anonymity is the way that you're actually able to stop lawsuits before they're ever started, because if people don't see that you own anything, come to find out that they don't actually sue, right? So what we do is that then you have your master LLC that you create, and it spins off its first child series, right? So we'll call it Child Series A of your parent. And Child Series A will then own a land trust. And the land trust will then in turn own the individual piece of property. So the way that works is that you deed the property into the land trust. The land trust is called, 123 Main Street Trust. Now that trust is anonymous. Nobody can find out who owns it because trusts are private documents. That trust is in turn owned by one of the individual child series. So what you've actually done here is that you've now created anonymity in the ownership of the actual asset, so people can't link you to the asset. You've compartmentalized the asset because it's owned by an individual child series of the Series LLC. And if anybody ever looks at this from any type of angles to investigate what's going on, all of it point back to my law firm, which then has it blanketed by the attorney-client privilege to protect the information from public disclosure. So the reason that this is so neat, guys, is because what you have effectively done is make it an incredible pain for anybody to come after you. Not to say that they couldn't, right? I mean, anything is possible under the sun, right? But what you've done is that you've hidden the assets, you've protected and isolated them, so that way if they come after you, there's very little for them to pursue. And when you put attorneys, which are essentially the people that are actually making the call on who gets sued or not, because these are the guys that get paid on commission to come after you or not, when they look at you versus looking at the next target, they say, this guy looks really difficult to come after. I'm not going to go after him. I'm just going to go after the next case that came across my plate. Because they have overhead, they need guaranteed paydays. So you don't have to make it impossible for anybody to come after you. You just need to make it more difficult to come after you than the next guy. And it's kind of like that old saying, you don't have to be the fastest one out of the woods. If a bear is chasing you, you just got to be faster than your friends.
Right. Yeah, exactly. So just to clarify, a couple questions about the trust there, because it's definitely very advantageous to avoid the situation at all by just simply no one knows that you're the owner. So is there any specific information that we need to know about the nature of this trust? Or for example, does the trust need to be in a specific state, or does the trustee of the trust need to be an attorney, like you say? Is that how it works? The trustee of the trust is the attorney, or where does your law firm come in when you said, your law firm is mentioned in the trust documents?
Yeah, so the way that it works is that the trust is a land trust. It doesn't matter where those are formed. It's just a type of revocable trust.
Okay.
And that's what all land trust is. A land trust is just a revocable trust that happens on a piece of land. They're all private documents. There's no public filing for them. So the only identifying information of the trust is where is the trust located. It has to have an address on the deeds, typically where it's located. That points back to the law firm. I typically offer my services to my clients to be served as what's called a nominee trustee, to appear as the trustee on the trust for the public filing. So people look at that and say, oh, it's Scott Smith. It looks like he owns 10,000 properties. Well, that's because I'm a nominee trustee for all of these, right? But then what happens is I am able to resign as trustee automatically by the trust document, and the client then controls the property. So at no time do we actually control it. And if you didn't catch all of that, guys, or if that sounds confusing to you, don't worry. There's a lot of little pieces like this that work into it that you can really get mired in the details on. That's why we offer unlimited contact with us on the firm to get all of the education about these pieces, because there's a lot of little details if you want to dig into them. But the trust is an absolutely essential portion of this because it creates the anonymity, but the transfer to the trust will also avoid any of the due on sale clause types of issues that we typically run into. And it also typically will allow us to avoid the transfer taxes and transfer fees that are associated with normally transferring a property and without having reassessments associated with it. So it's one of these neat instruments that gives you a cool caveat to create the anonymity, avoid the due on sale clause, avoid a lot of the other fees, and effortlessly move the asset inside of the asset holding company.
Yeah, that's really fascinating. And I'll tell you, just a quick note about what happens when these details are not taken seriously. If you are in the middle of a lawsuit, if you start to get tangled up and things start to go to legal and the attorneys are hired, et cetera, the first thing an attorney is going to do is they're going to pull all of the paperwork that's involved and ensure that every single document, number one, exists, number two, is signed and is executed in the right way. They're going to follow that trail of paperwork because at the end of the day, they're building a case and that case requires evidence, and the evidence is the paperwork. So it's critical that these little nuances that Scott was just mentioning, that's like the entirety of this process. It's these small little changes that make up cumulatively a very, very strong case to protect your own assets, which, it's something that you need an expert to handle, because if there's one, it's only strong as the weakest link. And so if one document's not properly executed, that's exactly what they'll be focusing on when they go and pursue, some kind of legal challenge.
Yeah, that's right, Hunter. And that's exactly the way it works. My background is in high stakes litigation, suing insurance companies. And that's what I did before launching Royal Legal Solutions over 5 years ago, and exclusively helping real estate investors across the country in all 50 states. So one of the things that I realized when I started this work is that investors really they need to understand what's going on with the legal, but they really shouldn't be involved with it and the actual execution, because if you're not doing this kind of work every single day, there's really just too many places to drop a ball. So what we do is we in-house everything for our clients to put them in a position to be able to just look at making investments and keeping track of the money. And then we take care of everything else in between, because we're a one-stop shop for real estate investors. And that includes how do we integrate things with the estate planning, how do you use solid 401ks and self-directed IRAs to help with your investments, really everything start to finish there, because there's so many little pieces that it can take a lot of time and effort to figure out how do they all integrate together. And then you're always wondering if you did them right. So that's what we offer to all our clients, is that start to finish type solution. Because really the most money you can make as an investor is out there actually finding the deals and hammering the pavement, right? So when we partner with people, it's really with that kind of growth in mind to say, we're actually going to be a leverage point with you for growth and not just, pushing paperwork, right? Because, I always believe too that we should always hire professionals that are in the same business we are in, which is why I'm personally invested in just about every asset class in over 10 different states at any time. Because being an active investor allows me to have that touch and feel of knowing how does this really need to work on an operational standpoint, a tax preparation standpoint, to really give the really dynamic solutions that people are needing. But, to digress into asset protection, that's really the solution that everybody, if you're actually owning physical assets like single family, multifamily homes, that's the solution that you should be looking towards, that we can have a consultation about. But there's another piece that I think that a lot of the syndication style investors that are placing money with other people and are more hands off really need to be considering, especially for people that have, above the $1.5 million in net worth. Hunter, how familiar are you with using the offshore trust options?
Yeah, that's a good question. I definitely wanted to talk to you about it. So let's get into it. So $1.5 million net worth, you have your investments tied up to syndications or things like that. Let's, in terms of international asset protection, I'm interested to get your perspective on that.
Yeah, so it's really one of those things that you really should think to combine a domestic with an international approach. Once you start looking at that $1.5 million and above, that rule that we typically use is, underneath $1 million, you have about a 3% rule. You should spend about 3% on your asset protection. And once you get above the 1.5 million mark, that's where we start looking and saying, well, maybe around 1% to 3% starts to make a lot of sense. But you should be what's appropriate to spend in this category. But what you can do is you can use the great domestic tools that we have, like the great LLCs that, from Texas, Delaware, Nevada, Wyoming, that have great charging order protection with them to be able to hold all of your assets. You're going to make all of your investments in syndication just directly from your asset holding company, because there's no individual liability associated with each one of those investments, right? Like there is with a piece of real estate where, somebody can slip and fall on a piece of real estate and sue your LLC and go after all your money. That doesn't really exist as a risk in the syndication sphere. But for either one of those types of investors, whether you're owning physical assets, you need a Series LLC with the anonymity in place, or if you're a syndication investor and you just need a normal LLC to be able to hold all of your syndication investments, your stocks, your cash, and other assets, you should always be thinking to pair those with an offshore option. So one of the things you can do with that is to look to set up offshore trusts. We set them up in a number of places, from the Cook Islands to Nevis. There's Bahama LLCs. There's a number of different options that have different price points associated with them. My favorite piece to look at is, what is your actual assets merit, right? You probably don't need a $50,000 offshore trust if you're just at 1.5 million. Right? That might not make sense for you, right? But that can make sense for somebody that has a higher net worth and say, well, I really want to close the gap on that last, 3 to 5% of what the best asset protection in the world is. Because guys, like, these types of offshore options, really do work, and they really do work. And even in situations where you end up with judges that have what's called a results-oriented outcome, meaning that, they'll kind of just disregard the law to get to the results they need.
Yeah, that's definitely interesting. And I want to circle back with that. Before we go on from the Series LLCs, I'd like to just ask a couple of questions, because I know that there's a lot of people that are going to be fascinated by this topic. And I also know that there's, like anything regarding asset protection, there's ways to do it wrong, and there's certain limitations of different strategies. So circling back to the Series LLC, we'll get back to international in a second. What are some of the limits of the Series LLC structure? What are some of the ways that the strategy can be taken the wrong way and therefore deemed ineffective? Or what are some of the cautions you would have with people that are pursuing the Series LLC strategy?
Yeah, so there's a couple of major things that you run into when you start looking at Series LLCs. The first is that there's not any case law over the last 20 years of anybody challenging it. A lot of people seem to think that makes it weak, and I actually think it makes it very strong. Appeals are very expensive, and they're also only can be used to interpret what the law is. So it can really only be used to interpret what an ambiguous law. Series LLC laws are very clear, and over the last 20 years, you haven't seen anybody challenge it to be able to say that, hey, this is, we're going to invalidate this. So to the contrary, what a lot of people think, that the Series LLC actually has very strong precedent just by the pure deafness to anybody bringing challenges to it. I also think that you have to live in a state that where you can create the Series LLC to use it, and that's not true either. Series LLCs are just LLCs. We've always heard of people, forming a Delaware LLC and using everywhere else in the United States. The same thing applies to the Series LLC. All the states also have internal liability shields for LLCs when multiple LLCs are working together, and that's when the same thing applies to a Series LLC. A Series LLC doesn't buy you any better protection than having individual LLCs. But what it does do is give you the ability to operate out of one bank account, have everything simplified for you, and give you the ability to be able to expand infinitely for free, while taking advantage of the great asset protection laws that are in place in terms of charging order protection from Delaware, Texas, and Nevada. So in that sense, the Series LLC is really the preferred option. You see more and more states that are adopting the ability to create it, every single year. And, more states are, I think you'll really see in the next few years that every state will have the ability to be able to create Series LLCs. It's just that those of us that are taking advantage of the laws that they exist today are just going to be in the front run, enjoying those benefits, just before everybody else.
Okay, you touched on a lot of things that I definitely want to dive into. I guess really quickly, though, I noticed that when you mentioned Nevada, Delaware, and Texas, you didn't mention Wyoming. Is there a reason for that? Or of the 4 or so states, which one is your favorite for implementing the strategy or otherwise? Yeah,
so typically what we look for is that we look for Delaware, Texas, and Nevada for the implementation of the Series LLC. That's a historical piece, right? I think Wyoming is just on the cusp of adopting a Series LLC creation to allow it. But Wyoming is overall a very strong LLC state. Wyoming is notoriously famous for their LLC creation that allows them to have anonymity, de facto anonymity in its creation. Those other states, you typically need another step. Right. To be able to add into the LLC creation to be able to create the anonymity, which the attorneys can do. But I have every reason to believe that when Wyoming finalizes the creation of the Series LLC and we have an opportunity to review that'll be another option we'll move into.
Okay, and when it comes to owning assets that are different, is there any sort of limitation in terms of that? So let's say, for example, that I own, and I mean own as in actively, right? Because we made that distinction at the beginning. So let's say I had some commercial real estate, some residential real estate, and let's say I had a ice skating rink. Could I put all of those in a Series LLC and be fine? Or should it be delineated with the different types of businesses, the different types of investments, et cetera?
Yeah, so the Series LLC can do anything a normal LLC can do, right? The questions that really come up with saying what types of assets should I own inside of one Series LLC actually has to do with taxes. One of the advantages to a Series LLC is that if you have the 5 assets and all of them have the same type of tax treatment, like they're all passive income from single family homes, it'll all channel up through one parent and they'll be reported on one EIN number. Right. So then it's a way to simplify your tax returns. Right. Once you start mixing passive income and active income together and one EIN number, then all of a sudden the IRS can then elect which way it wants to do the tax treatment. So the general rule of thumb is that you should never mix your types of income inside of the same company structure or underneath the same EIN. So that way you can control the tax consequences of it.
Okay. Yeah, that makes sense. And let's talk about, so obviously there's only a couple of states that are allowing people to create Series LLCs, but are there any states that have said explicitly, we will validate and we will confirm that the Series LLCs are valid in our state, regardless of what state they were created in? So just to clarify, let's say, for example, that you lived in Nebraska and you have a Delaware LLC with the Series LLC. Has there been any case law or anything similar where Nebraska has said, even though it's a Delaware LLC, we will absolutely confirm that the separation of that liability is, valid, regardless of where the assets are held, for example?
For that confirmation to exist, somebody would actually have to challenge it first at an appellate level, and that hasn't happened. So that can only not happen in this instance whenever there's nothing to be gained. The litigation attorneys that have the most to win look at that and say, well, if we would win that, we would get a huge payday because we'd be able to collapse the structure, but we're not even going to bring the claim. But because the reason why is because the laws and recognition are capable of satisfying that burden as they currently exist. And that relates to the full faith and credit clause of the Constitution, that states recognize each other's laws. It also has to do with the longstanding tradition of states recognizing each other's LLCs laws and recognizing that Series LLCs are just a continuation of an existing body of law with LLCs. So it's actually a necessary thing for a state to do, to take an additional stand to overly confirm that they're going to recognize an LLC structure that they've always historically recognized.
Okay, got it. That makes sense. And is there any states that have outwardly said, regardless of the fact that this hasn't been challenged, we're not going to do this?
No, there's no states that have said that they've passed any legislation or otherwise dictated that they're not going to recognize Series LLCs as an entity structure.
Okay, got it. So, you mentioned the LLCs being a great vehicle for asset protection on different kinds of income. Where do S corps fit into this? Like, when do you decide that S corps would be the preferred mechanism as opposed to an LLC?
S corp should never be used for asset holding. S corp should only be able to be used for active income types of businesses. I mean, for most real estate investors and most investors I think we're talking about here, you never want an S corp in play in most situations. That has to do with the asset holding for a couple of reasons. One, an LLC gives you an option of whether you want it to be taxed as an S corp or not. Right. So why wouldn't you always avail yourself of that option? LLCs also have lower obligations in terms of what they have to do with yearly minutes and other maintenance factors. So they're cheaper and lower burden. And the S corporations don't allow you either one of those, and then you're pigeonholed into what it can do. There's also some strange tax consequences that can happen when you own assets directly inside of an S corporation that has to do with how you can transfer assets in and out. We have a number of clients that were set up incorrectly with S corporations that had physical assets held inside of an S corp, and they had really negative tax consequences associated with that were ongoing. But that would really played out at the time of if they ever disposed of the asset. So essentially, they had assets that were trapped inside of an S corp because the tax treatment would have been so bad to be able to move them out or to sell out of it.
Right.
So we've seen that been done incorrectly a number of times. What you should really always do is use a Series LLC or an LLC, depending on your situation, to be able to do the asset holding, and then run your active business as an LLC that's taxed as an S corporation, if that makes the most sense according to your CPA. A lot of people are doing that S corp tax election mainly to avoid self-employment tax, and it typically starts to make sense to start looking that route once you start making over $50,000 a year or more inside of that business.
Okay, that makes sense. And I appreciate the clarification there, because just to clarify, if anyone that doesn't know this, and correct me if I'm wrong, but the LLC has something called the S-elect which allows you to basically elect to be taxed as an S corp. And the whole point is an S corp has a lot of maintenance requirements that if they're not completed accurately and you can't prove that they were, then attorneys or courts can pierce the corporate veil. And it's much easier to do that if you can say, look, I don't have my access to my minutes. I don't have anything like that, which are required if you own an S corp or are a partial owner of an S corp. So just something to consider. The LLC has the flexibility. The costs are typically lower, but you still have the flexibility to be taxed as an S corp. Is that all fair before I move on? Okay.
That's perfect, Hunter.
Okay,
you know
great.
this stuff, man. You're like a seasoned pro at the asset protection.
Oh, well, it's just a matter of having conversations with smart people, which is something I've been very fortunate to be able to do. So, like yourself, of course. Now,
Okay.
This is something that obviously has come up a lot as people have been realizing that they don't have the ability to take advantage of the 1031s as much as they thought they could when it comes to syndications. And that has really increased the popularity of the DSTs. So I wanted to know your thought on Delaware statutory trusts and why this structure is compelling and what this allows people to do that are potentially investing in real estate and especially syndications.
Yeah, the DST is a neat structure because it allows for 1031 exchange opportunities, right? So there's a number of different ways you can use it. One of the more powerful ways that we've seen just average investors use their own multiple physical assets is located inside of California, because the DST allows the series creation, just like the Series LLC. It allows anonymity in the ownership. But what it does that's special for California residents is that it also avoids franchise taxes. Since the LLCs are subject to franchise taxes and trusts are not, it is a trust. It's the only type of trust that actually provides, that domestic style trust that actually provides asset protection. Above that, you would actually need a foreign trust to do so. That you can really exploit it as terms of cost savings and protection for the California investor. But for other investors, we've seen a lot more people move into, using their 1031 money inside of DST structures because of that special caveat that allows you to do that, which LLCs can't.
Got it. And so if you invest in an asset through a DST, you can potentially 1031 out of that into a new DST. Is that correct?
That's right. Yeah, you have to close out that investment, and then you would move it into a new child series of the DST. So you'd have the DST that you create, you have one investment that's in child series A, you 1031 and move it into child series B. What you're going to find with a lot of the 1031 rules is that what IRS is really concerned about is actual change in ownership from one party to another. They don't really care that much about form. So if you want to 1031 out of a property that you had your personal name and you actually buy it into an LLC, which you wholly own, IRS is still going to say that still qualifies for your 1031 exemptions. DSTs are a little different because DSTs can actually 1031 in and out of the same structure, inside of the same series, and you can move 1031 money inside of the DST from outside. So it has that extra flexibility.
How much value of assets would you need to make the DST structure economically viable? Like, would you say that if you were typically investing in a syndication of $50,000, that it would be advantageous for the sponsor to create a DST structure and allow for people that are investing $50,000 or $100,000 on a $3 million, $5 million raise? Would that be something that you would consider economically viable? Or does it need to be 10 times that size?
No, I would say that it's economically viable to do if you're going to be looking at that as a business strategy that proves any type of viability or hope for you, not just now, but in the future. One of the great things about the DST is it has that infinite scalability through the use of the child series. So when you're making an investment of anywhere between $5,000 and $15,000, depending upon the complexity of the deal you're trying to put together, what you're really investing is saying, this is my foundation upon which I can scale my future deals, no matter what they are, from now and for the rest of my life. Right? Why would you ever invest in a structure that doesn't allow you that type of flexibility in that continuity? I don't know if you've ever had, maybe the audience members would resonate with this, but if you've ever had to change the legal structures that you're using, like changing your bookkeeping and your accounting, your banking, all those things are incredibly painful to do.
Yes.
I highly encourage everybody to just set it up right the first time. Right? And set it up with the flexibility the first time that allows you to make the plays you're going to want to make, and even plays that you might not even foresee making for the next, 3 to 5 years, right? We're in a long-term game, probably for 30, 40 years, and what we're doing, right? So it's really a short-sighted approach to save a couple of pennies now, but then just defer the headaches that can actually prevent you from growing, because you might not want to have to take those headaches in the future, and that can actually cost you real dollars then. So that's my only advice there.
Yeah, that's fair. So as a sponsor, let's say if you were raising capital for a deal, what would be some of the things you would consider, some of the parameters, if you were deciding whether to go with the DST route or the LLC route?
It really matters on, who you're doing your raise with, right? And who you're targeting for your investors, right? So what's neat about the DST is that I can create an asset class with a number of investors, and we can purchase an asset. And then let's say somebody wants to get out of the asset, and then a new person wants to get in and buy it, and they have 1031 money. Well, they can actually 1031 exchange and buy their stock in the DST for that particular asset. So it allows this kind of continuity for deal flow there. And people that are looking to raise just generally 1031 money from the sphere of everybody, of the huge pool of 1031 money, I would say that's also a great person to be a candidate for the DST. If you look at guys like Dwight K out in California, they're buying parking garages and they pay out, I think somewhere between 6 to 8% interest on it. And what they've done is that they have these huge assets, and then they just open up the doors to say, if you have 1031 money, we have places for you to park it. Because what if your 1031 timeline, craps out or whatever, right? You're going to need a place to stash that. There's so much 1031 money out there that if you're trying to go after that kind of money, you need to be thinking DST just to allow yourself that option.
Wow. Yeah, that's fascinating. It's something that we haven't done as a company. I actually have not invested in a vehicle which has done that, but I've been very close to those transactions. So it's probably something we'll consider in the future, especially, because there's so many gains people have received over the last 10 years, it starts to become a really important question. And so, yeah, I'll definitely, continue that conversation internally and with our own attorneys as well.
Well, think about the windfalls that you make too, about being able to take money in like that, and then what kind of negotiating position you're into on that money, right? Mm-hmm. If you have people that are like, I have to be able to put this in a 1031 protected type investment, or I have to take these monster gains. So, if you actually have that option available to you, that can be a huge amount of cash, right?
Yeah.
With all the gains people have made. So it's really like a DST makes sense even as a park it vehicle, right? So we have something over here that's just ready in case we run into investors like that. We got a place for them to move into that they can take advantage and exploit that. And just with one investor, you'll likely make all of the money back that you had to make with setting up the DST.
Yeah, that's a good question then. So how much does that typically cost, setting up a structure like that?
It depends on exactly what you're trying to achieve with it. And typically, I would say that you're looking at somewhere between $5,000 and $15,000.
Okay, that's fair and totally reasonable. Yes, I mean we've had several investors come to us looking to invest $1.5 million or more because of properties they've owned, and it's very challenging to do. We do have the 721 exchange option, which is the UPREIT version, and that's something that we haven't done, but we have also, again, very close to those transactions. So definitely an interesting conversation to continue as the expansion that we're witnessing right now continues as well. So, all right, cool. So is there any caveats that you wanted to mention regarding the DST structure or otherwise? I know that we do want to circle back regarding asset protection, but any caveats regarding the DST versus LLC, et cetera?
Nothing too particular. I think it's just a really great option if you're trying to do your, deal making on your own. DSTs make a lot of sense. If you're a California resident looking to avoid those franchise taxes, and then the DST is going to be a great option. The DST is arguably even stronger than LLCs because LLCs have been chiseled at, in some respects over the course of the years, whereas these trust structures have extremely high protections that haven't had that happen to them. So a lot of people are like, say, what's the most secure domestic protection I can get? And a lot of people are going to the DST for that.
Okay. Yeah, that's fair enough. All right. Now, I definitely want to ask a couple of questions about the international asset protection. I really like that you mentioned, $1.5 million of value as being something you wanted to protect, because that's when it starts to be scalable. So I've heard a lot of things about the Cook Islands. I've heard a lot of trusts basically being created there. Let's talk briefly about the typical international protection plans that you put together for clients in that $1.5 to $5 million range.
Yeah, so typically what you're looking at is some type of domestic structure that's put in place, right? First we want our insurance to be able to cover it if something goes wrong. And if the insurance doesn't, then we look for our domestic to be able to protect us. The domestic looks like it's going south. That's when your offshore trusts have an automatic trigger built into them that says when XYZ event happens, all of the assets and ownership is actually immediately transferred to an offshore account, into an offshore holding. So there's a number of different places that people tend to like for it. But to not get into nitty gritty details on those pieces, it's really just that last 3 to 5% of protection that you kind of hope that you never have to use. But once you're looking at the 1.5 plus net worth range, it starts to make a lot of sense because the amount of effort that you'd have to do to rebuild that money is likely much greater than the $20,000 to $50,000 that you're going to spend on establishing your offshore option.
Okay. Yeah, fair enough. And you mentioned that there are some judges that are looking for the results rather than legal documents. And I know that this is when international protection really comes into play. So just to paint the picture more clearly, you could have a really ironclad LLC structure, which is there's a manager of the manager, and that manager is an entity, and taking away the anonymity, because that really does help this whole process tremendously. Basically, if the wrong judge sees these documents and sees that you've spend a lot of time and effort putting together an asset protection plan, there is a chance that they could say, I'm just throwing all of this out and we're just going to go to the bank accounts. Now, international asset protection has this unique way about it of someone else outside any jurisdiction can say no, and there isn't really a way to force them to go inside those bank accounts. So could you kind of go into that, details of that? And even if you had an experience of that, we'd love to hear about it.
Yeah, so the experience that I've had with it is that it's extremely strong, right? Because what happens is that you move the assets from anything that's inside of the control of the United States to organizations that are set up and that live for 100 plus years just on having consistency with how they operate. So these are organizations that you can really trust because the livelihood of all of their families are dependent upon the fact that they are dependable, right? Because that's who those people are that live over there, right? So that's where the really makes a lot of sense to be working with people that have longevity, especially when you get into something that's quote unquote like and saying offshore. I don't really know how much control that I have here, and can I really rely on these people? You just have to look at the track record over time, right? That's really the best judge for that. But what's really neat about it is that once you can take the assets and they get, we have a triggering event that will happen, then all of the assets get moved offshore. It doesn't matter what the judges say. It doesn't matter because the United States doesn't have any power in the Cook Islands to be able to force a seizure or do anything with those assets, right? That's what makes it so powerful. There is a concern that you have with sometimes, it's only happened a couple of times where you actually have judges where people are actually actively committing fraud by moving offshore. And in those instances, what they did is actually jailed the person domestically in contempt of court. Right. Mm-hmm. So what's really important in these situations that you take a proactive approach to be able to have the assets moved on triggering events that are going to occur before there's an allegation of fraud, before there's a real allegation that what you're doing is really fraudulent. Right. And that's not part of something that was predetermined of a business process that's really outside of your control. And that's why it's so exceptionally important that we have something that's a triggering event in here, because a triggering event isn't inside of your control. And that's just the legal mechanisms that were put in place before the lawsuit or whatever the instance was ever occurred. So those are the workarounds that you use to be able to circumvent, sure, you protected your money, but now you're in jail. That doesn't actually help you, right?
Right.
You actually need to be free and with your money to be able to really enjoy it. That was something that came up, and now the offshore specialists like myself have adapted to that to ensure that we don't put clients in that kind of position.
Awesome. Well, Scott, we covered a ton of information on this call. I just want to give you the opportunity to tell listeners more about how they can learn about your firm and what you do. And I know you have an awesome podcast I'd love you to get a shout out for as well.
Yeah, definitely. The podcast is called the Real Estate Nerds Podcast. It's a great podcast that goes into the best and worst deals of real estate investors and what they did or didn't do that led them there. We also have consultations that we do through the royallegalsolutions.com website, or if you call us at 512-757-3994, we can set you up with a consultation. We charge $150 for the consultations, but the consultation is actually a blueprint of a map of what exactly you need to do from here to be able to have the asset protection you need at various different levels, from what you might need to put in place now, what you could look to say once you hit X income number, et cetera. You can take that blueprint, you can go anywhere with it to any attorney. It's going to be our best ideas into it. So it's a very high level of work product that goes into that consultation meeting with you. It's not just a, hi, how you doing with an attorney? We get into the nitty gritty details of your exact plan with that. So if you get that and get that high level information and make a decision on what's going to be right for you, at just the royallegalsolutions.com website, or you can call us at 512-757-3994.
Awesome. Well, Scott, thanks again for your time.
Thanks, Hunter.
All right, listeners, thanks for checking out the episode. As always, the contact information for our guest will be available in the show notes, which is hosted on SoundCloud, iTunes, and Stitcher. Don't forget, if you want access to some of the free goodies that I'm talking about at the beginning of these episodes, like free ebooks, weekly investor emails, and articles about some of the most important investment-related topics, make sure that you have created an account with CFC, because this stuff is automatically available. You can do this by going to cashflowconnections.com and signing up as an accredited investor. Of course, if you have any questions, feel free to email me at hunterthompson@cashflowconnections.com. Thanks again.